Your favorite Pokemon lawyer is back. This is Eli from Mile High Pokemon. Today we're doing part 2 of the series of Rattle's lawsuit. Today we're going to talk about some fun stuff like how much lawyers cost and what racketeering is, which is one of the claims that was made against Rattle by Sean. So today we're talking about some viewer questions, but others are still outstanding. We'll get to those. Please leave your questions below if you're interested in something. Talking about false light, wrongful interference, civil RICO, so those three are the other claims against Rattle, and then we're going to talk about injunctions. Essentially, Sean's trying to force Rattle to shut up and take his videos down right now. So what would that take to happen? Before we get into that, once again, my regular disclaimers: I'm not a lawyer, and I'm not Rattle's lawyer. I mean, I am a lawyer. I'm not Rattle's lawyer. I'm not your lawyer. And my views are based off the research and background knowledge I've done, but I might be wrong, especially on RICO, which I actually have never worked with. So I might be wrong on RICO. I feel like I got the handle on it, but don't take me as legal advice ever. I'm just some guy on the internet that knows some stuff about law, and hopefully you find it interesting. The other big disclaimer is I've not seen all of Rattle's videos, so there may be something that he has done that I just simply don't know about it. And I couldn't know about it. So first off, some people asked about how much a lawyer costs. And the big answer is that it depends, and there's a huge range. So why don't you look at this chart I have over here. It's the annual salary of lawyers. It used to be a binomial distribution. Now it's a trinomial one. This is from the class of 2018, so we're 5 years out. They just checked in at the 5-year date, how much they're making. And what you're going to see is the largest number of lawyers, it's about 80% of lawyers, 75 to 80%, make below the mean, right? They make between like $45,000 and $75,000. That's like 80% of lawyers. And then you have two spikes. It used to be one spike on the higher end, and those are the high-end lawyers, and they make a shitload of money. It's one of the biggest misconceptions, actually. People think if you go to law school, you'll make a lot of money, but what you see here is actually like 80% of lawyers don't make very much money, and sometimes they can't even pay off their debts with how much they take out. So it depends on which side you're hiring. For most things, regular things, you probably don't need one of those high-tail lawyers. Those are the lawyers that like corporations are hiring. And if you got a drunk driving charge or something, for example, you don't need to pay out the wazoo to pay, $400 an hour or whatever for work. But some areas where it's more niche, it might be more worthwhile to pay out for one reason or another. For example, here, the next step of the process of the lawsuit is almost certainly going to be, I don't know what Rattle's going to do, but probably he'll be filing a motion to dismiss. And if you get it thrown out at that first stage, you might get legal fees paid back under SLAPP, the anti-SLAPP provision, and then also you don't have to go through discovery, you don't need to do all this other process. So essentially, it will save you the rest of the lawsuit. And it may make sense to pay a lot of money on the first step of the lawsuit to get it dismissed entirely so you don't have to pay for everything else that can come after that. So on a motion to dismiss, you might be looking at something between $3,000 and $10,000, depending on the complexity, just to get that first document filed. First two documents, I guess. It just sort of depends on what your lawyer's doing, but the first big step. But after that, it can rack up quickly. It just depends on how much time you have to spend on discovery, how many interviews you're doing, how much time your lawyer's having to, look through shit, right? I think in a case like Rattle's, where he already has a lot of the evidence and defense prepared and knows where shit is, and already knows what could be potentially used against him and all that, it might take less money to pay out for a lawyer because he's already can help in that process. But essentially, it depends. It really, really depends. So the next thing we're going to talk about is false light. So if you remember last time around, we talked about libel, which is when you make a false statement, a fact about someone. And false light is similar. And here's a summary that ChatGPT gives. I feel like it's a good one. Speech that places someone in a false light typically involves making a statement or creating an implication about someone that is not true and would be highly offensive to the reasonable person or embarrassing. It's a type of expression that suggests something false about someone's actions, character, identity in a way that would be damaging to how they're perceived by others. So the elements, if you remember, the elements are the things you have to prove in order to win in a lawsuit. The defendant, with knowledge of falsity or reckless disregard to the truth. Now remember, that part is from the same thing as libel, actually, if you have it against a public figure, gave publicity information, placing the plaintiff in a false light. And as we said, the false light would be highly offensive to a reasonable person. Now, what's the difference? This might sound a lot like libel. The difference is that libel has to do with reputation, frequently in a business sense or something like that. False light is a privacy tort. And it works a little differently in the sense that it's not just monetary. If you libel someone in a business sense, you might hurt them in terms of, losing business or this or that. False light concerns things that could be personal. So, for example, if you lied about someone who was unfaithful to their partner, if you decided to lie about someone having other personal details that were highly offensive, even like, oh, this person, like, I don't know, this person, like, really likes to sleep until 3 p.m. I'm just kidding. That's not highly offensive. But you get the idea. It's something about personal. And so it's sometimes more difficult to quantify, but it's still something that would affect a reasonable person supposed to give recourse to someone who really has been embarrassed in front of the community or something like that. It's sort of strange because to the extent that any claim fits here, libel obviously fits better to some extent than false light. Not that either one would be successful, because a lot of the speech that Rattle did about Sean had to do with Sean's business, not about his personal character, other than him being, I guess, a scammer, if that's an allegation of some sort. But it's really, I don't think it fits as well, right, in terms of the allegations themselves. So that is that one. Next one is wrongful or tortious interference. That's another thing that he was accused of doing. This is wrongly or unfairly interfering with someone else's business. It's not just plain competition. Like, you have to do something worse. If an example of this would be, like, let's say someone who applied to a job, actually, like, got the job and was in the process of negotiating a salary, hadn't accepted it yet, right? If you call the person's future boss and, like, made up some shit about them so that they would get their offer retracted, that is the sort of thing that is wrongful or tortious interference. It has 4 elements. The existence of a valid contractual relationship or business expectancy. This means that someone has a contract that's already in existence or about to be with another entity. The interferer's knowledge. So essentially in this case, that would mean that Rattle would have to know that Sean Bassick had a contract with someone or was about to have a contract with someone. So it must be more than mere hope, and the person has to have actual knowledge of it. And then intentional interference, reducing or causing a breach in the termination. So if Sean Bassick lost business, that would be part of it. But the thing is, the conduct on Rattle's part would have to be improper. This is a wishy-washy term. We'll talk about it in a moment. But just simply calling out someone's bad business practices, if they're true, is not improper. It has to be something that, for public policy reasons, for legal reasons, is improper. And so there must be also a causal relationship. And that means that if Rattle made a video that put Sean Bassick in a bad, made him look poorly, and then Sean Bassick lost a contract, but it was for a different reason, then you can't win through tortious interference. It has to be, like, directly related. So as I said, improper interference is sort of a wishy-washy term. There are, like, these 7 factors or whatever that might be relevant, which is the nature of the actor's conduct, the actor's motive. Motive is sort of the most important, like, what's the reason you're doing this? Is it a bad reason or a good reason? The interests of the other with which your conduct interferes. The interest sought to be advanced as social interests in protecting the freedom of the actor against the contractual interests of the other, the relations between the parties, the proximity, right? It's a hard thing to suss out, and so it's difficult to say yes or no. Sean Bassick's claims are meritorious or not, right? But what we're really getting at is, first off, what's the reason that Rattle did this speech? If you're looking at consumer protection, which is what I presume Rattle would say, that's sort of a big thing. If you're not just trying to destroy someone's life, right? The nature of the actor's conduct, is it, it's reporting truth or something like that, right? That's probably not wrongful. Then you've got, like, these social interests in protecting the freedom of speech. Not just that, but the social interest in protecting people's from getting scammed or something like that against the contractual interests of the other. And then F is sort of relevant too, because proximity or remoteness matters. What I mean by that is if Rattle made a video, that's very different from Rattle calling up a client of Sean Bassick's and saying, hey, you shouldn't do business with this guy. What you're really looking at is the causal chain and how many degrees away you are. So you're less likely to be held liable for something like improper interference if you didn't directly interfere, like first party, you call the person or whatever. So this is the way that the restatement, which is sort of like the main treatise, summarizes it. The issue in each case is whether the interference is improper or not under the circumstances, whether upon a consideration of the relative significance of the factors involved, which we just talked about, the conduct should be permitted without liability, despite if its effects of harm to another. The decision, therefore, depends upon a judgment and choice of value. So it's literally like a balancing test, right? I think from what I know, and I don't know much, as I said, Rattle's strongest argument would probably be like that he didn't know that Sean Bassick had X contract with another, and so Sean actually talks about the two specific things where he was harmed. But the number one way to win on a claim like this would to say that you didn't know about the contracts that you ruined, because you can't do tortious interference if you don't know about the deal that you're ruining. So Sean, in his complaint, says he had 2 deals ruined. The first one, he said he contracted to sell $2.4 million of Omega Mystery boxes to Party One. The deal was partially performed when Rattle was making videos, and the other party canceled the transaction as a result of the videos or something like that, and Sean had to sell the remaining inventory at a loss. Transaction 2, very similar. Sean Bassick contracted to sell $130,000 of mystery boxes to Party 3 after seeing Rattle's videos, also backed out of the agreement. So the first question here is, does Rattle know who these people are? Maybe. I didn't watch the videos long enough to know. But number 2 would be all those factors that we talked about. To me, it seems like Sean is a weak case, but there might be facts I don't know about. Now we're going to do RICO, which is, I pasted in this headline from the New York Times because Young Thug just had a RICO trial, pretty much suggesting the rapper had a whole criminal enterprise. I want to provide the caveat again that RICO is what I know least about in both of these videos between the two. I know least about this because I've never worked on a RICO case. So this is from my own research and whatever. So the reason why RICO started, or why these laws were put in place in the first place, is you had pretty much criminal organizations, gangs or whatnot, and it was really difficult to charge people for the sum of the activities of the organization, because each person would only do one part of it, right? Like if you had a murder for hire, you'd essentially have like one person take the money, another person like buy the gun, a third person shoot the person, right? And in between, nobody knows what the other people are doing. So like the person who bought the gun doesn't know that it's going to be used to go kill someone, for example, or the person who took the money. This was a way to get at that, and it was supposed to say, like, we don't really care whether you know for sure about these other things. We're still going to hold you responsible because you sort of know that other shit's going on, even though you don't know exactly what's happening. So from what I understand, the civil RICO law is heavily enforced in Arizona, is heavily based off the federal one. And so the elements are conduct of an enterprise. That's the important part. So it's not just of a person, it's of the enterprise, through a pattern of racketeering activity. That means more than one instance that is related, causing injury to a plaintiff's business or property. So essentially it's like, if you don't need to necessarily have a business for this to happen. Any sort of organization, as we'll talk about in a moment, can qualify if it meets the other elements. So for example, if you had a group of scammers that was doing that were working together, that could be RICO. So the first question is, what is an enterprise? It's like a key term, right? It's any individual, partnership, corporation, association, et cetera, where people work together. And it has to have a common purpose to engage in a course of conduct. So like if you just take this literally, the Rattle Discord group or whatever could be an enterprise, because it is a bunch of people gathered together with a common purpose, which would be just talking about Pokemon stuff, exposing scammers, whatever else is involved, right? I think that someone could make an argument that that would count as an enterprise, right? But then you have to ask, what is the illegal conduct involved, and is that on behalf of the enterprise being carried out, right? Sean Bassick is claiming there's 2 main things that is illegally happening through the enterprise or whatever. The first one is asserting false claims intentionally or recklessly. So he's suggesting that it's not just Rattle doing libel, but a bunch of other people in the Discord doing libel, and this is like all part of the same criminal enterprise. And the second one is restraint of trade or commerce. I'll talk about that in a moment, but it's sort of dumb. So essentially the question is, first off, is illegal stuff happening? I mean, I think it's fair to say that maybe some people have threatened Sean Basilek, or maybe some people have done libel, but it's probably not happening at the enterprise's direction for the purpose of the enterprise or whatever, anything like that. Rattle, very likely, based off what I've talked about, didn't break the law by talking about Sean Basilek, right, or didn't commit a tort. So I think it would be very, very difficult to prove that the purpose of the enterprise is to lie about Sean, or lie about people generally, or B, threaten his family or whatever else, right? I think that would be very, very difficult to show that the isolated instances of allegedly this happening was carrying out the purpose of the Rattle Discord server or whatnot. I think that would be very difficult. Of course, I think Sean Basilek is trying to get to discovery, right? Sean Basilek is trying to get messages or something like that. That suggests that this was a goal of Rattle or a goal of people in this organization or the Discord group, right? Because if Sean gets messages between people being like, we're using the Rattle Discord or like talking about it to do these illegal things, then he has a stronger case. I just simply, based off what I know, doesn't seem like that happened. But that's really the sort of discovery I think Sean is trying to get at. The second one that he alleges is illegal is a restraint on trade or commerce. That's sort of silly. That's an antitrust provision. So, for example, if we had, I don't know, if I owned a laundromat, right, and I was paying off all the neighboring laundromats to close down their business so that I was the only laundromat and I had a monopoly, that's the sort of restraint trade or commerce they're getting at. Or if, for example, I banded together, I own a laundromat and I banded together with all the other ones not to hire this one dude, that would be restraint of trade or commerce, potentially. I think that talking about someone's bad products or about how something could be a scam, that would not qualify under an antitrust definition, at least to my knowledge. So that seems a little ludicrous. But those are the two things that allegedly the criminal enterprise of Rattle's Discord is doing. I think it's a little silly overall because this law originally was supposed to like chase after like criminal gangs and stuff, and that is not this. But, you know, that's why I had the Squirrel Squad picture at the front, because the Squirrel Squad, you know, out for trouble. Last thing, we're talking about injunction. So if you file a lawsuit and you win, depending on the type of harm you suffered, you either get damages, which is the more common one, or an injunction, which is like forcing someone to do something. Those are pretty much the two main types of remedies. Sean wants both a preliminary and permanent injunction. Preliminary injunctions are for while the lawsuit is still happening, before it's resolved. And Sean wants Rattle to remove all the videos about him and pretty much shut up and not talk about him again. He also wants something permanently after the lawsuit is done to pretty much prohibit him from libeling Sean again. There are 4 elements to get a preliminary injunction. First off, you have to show a strong likelihood of success on the merits. This is, as you're going to see, this is going to fall apart. There's no way that Sean Basilek gets a PI. Because, first off, as I've suggested, maybe Sean has a chance to win. I think it's unlikely. But to get a PI, you don't just need to show that you have a chance of winning or a good chance of winning, but a strong likelihood of success. No way. Number 2 is the possibility of irreparable harm if the relief is not granted. What this means is not monetary harm. So you have to show that you're going to be hurt in a way that nobody could ever pay you back for. Like, it's a different classification of harm. For example, if I was having my free speech rights suppressed by the government, that is a sort of irreparable harm we're talking about, because no amount of money would make up for the fact that I'm not allowed to speak. Whereas here, theoretically, if Sean were to win, he would get money for the business damages. There's not, I think, the sort of irreparable harm that would normally be involved in a PI. Next, you have the balance of hardships, which is just like who's going to be harmed more by an injunction, a PI, and then the last one is public policy. Usually, public policy as well. Enforcing the law is a good public policy. Here, that's not really applicable. So there's other types of public interest like safety, and here, free speech, the right to free speech, would be an important public interest. But overall, I feel like he's going to fail on PI. And that's pretty much it for today. I appreciate everyone watching. The last video is my most successful ever on the channel, or about to be. We're number 2, but it will be. I'm happy to answer any viewer questions you have. Please don't forget to subscribe if you liked it. I just was blown away with the success of the last video, which is why I've made more. And I thank you, every single one, for watching the video today. Have a good one.